All right, everybody, welcome to the Broward Real Estate and Business Network. I am attorney Alex Johnson. I've been practicing in Broward for 30 years. I do closings and landlord tenant. And this week we're having a special presentation from Jeff Hittleman, who is an attorney for Coast to Coast Legal Aid. So without any further ado, I'm going to turn the hosting over to Jeff, who will discuss the numerous and recent changes to landlord tenant law. I don't recall any period in history where the law has changed so much in such a short period of time.
I was just thinking that, Alex, for an area of law that's usually very stable,
Yeah,
we've had so many changes. We've had changes in the last month, we've had changes in the last week, and we actually have some changes within the last day. So yeah, there's a lot of new stuff going on. And thank you so much for having me. I'm definitely looking forward to the Denny's presentation, the Denny's meeting. But until then, let's talk about some of the changes in landlord tenant law.
Jeff, can you tell us a little bit about yourself before you launch into the presentation?
Of course.
This is our first time meeting. I've been friends with your dad for years and years.
Thank you so much for having me. I am a lawyer at Legal Aid, Coast to Coast Legal Aid here in Broward County. And I do eviction cases. I actually do eviction defense from the tenant side. So hopefully we can provide some interesting perspective today. Welcome to Keeping Your Housing Out of Jeopardy, landlord tenant updates and changes. Here are today's categories about Broward. Can you hear me?
I'm hearing some background noise. You're the host, so please mute everybody.
That might be me. Let me try this again, Alex.
Okay.
Let me try this again, Alex. Sorry about that. All right. Here we go. Welcome to Keeping Your Housing Out of Jeopardy. Updates to Howard's landlord tenant laws. Here are today's categories about the changes in the law. We will talk about the rent increase ordinance, along with the termination of tenancy ordinance. Mia's law, which was just passed yesterday, just signed yesterday, and what's being called a Broward Bill of Rights. At least I hope I have some time to talk about our office and how we help the community. So as Alex said, landlord tenant changes have been in the news a lot lately, more than we can ever remember. Starting with last month, the Broward Commission passed a rent increase ordinance. Just yesterday, the governor signed Mia's law, which we'll talk about, has some changes to landlord tenant. And last week, the Broward Commission signed what's being called a Tenants Bill of Rights in Broward. I think Alex will start with rent increase for 10. When did the new rent increase ordinance become effective? It's actually, I think Alex knows, it's actually in effect now. It was signed into law on May 2nd. So it is the law for Broward County as we sit here today. Now, what amount of a rent increase? How much does the landlord have to propose increasing the rent to trigger this ordinance and these new protections? It's 5%. It's 5%. So if a landlord's looking to raise the rent by 5% or more, then these rules are going to kick in and govern how the rent increase can go. Now, this is a real new one and a fairly significant change to the law. How much notice does the landlord have to give if they're going to raise the rent? This new ordinance says 60 days. Landlord's got to give a full 2 months notice to the tenant that they're going to be increasing the rent. This is a significant change. I mean, there were a lot of cases where there was no notice required, and even at best 15 days notice. So this is a real significant change in the law here in Broward. Now, this ordinance kind of lays out a procedure for how this is supposed to happen. And basically, the landlord gives the tenant a notice that says we're going to be increasing the rent 60 days from now. And then the tenant can either accept that, try to negotiate and reach some kind of compromise, or the tenant might reject that. And at that point, either the tenant would have to move or landlord would have to call Alex and talk about eviction proceedings. This is how the ordinance lays out the process on the rent increase. This might be the most interesting thing of all, because I've really never seen something like this. The Broward Commission, who can enforce this? The Broward Commission listed two groups. They listed code enforcement and they listed law enforcement. I have no idea. Any thoughts on what law enforcement would do if they were called out to someone saying their landlord's increasing the rent?
I know.
Nothing.
Exactly what they do. They say it's a civil matter.
That's my 100% guess, that they would say this is a civil issue. So I'd be shocked if anything like that happened, but it does say it in the ordinance. And we're not exactly sure how code enforcement is going to go about enforcing this. So I guess we'll have to wait and find out together. Now, to go along in that same ordinance, they passed some new rules covering termination of tenancy. And these cover month-to-month tenancies, where someone doesn't have a lease, they're just paying rent monthly, or their lease is expired and they're just living there paying the rent monthly. It covers those types of situations. And same thing, the new rule says a landlord has to give a month-to-month tenant 60 days notice that they're ending the tenancy. Again, a pretty significant change. For as long as I can remember, it was 15 days. So we've kind of quadrupled the amount of notice here to 60 days. An really interesting detail in the ordinance is it says the tenant has to give the same amount of notice if they want to end the tenancy to the landlord. So I guess it works both ways. I haven't seen one of those yet, though. I'm curious if anyone's had any cases like this or any court rulings. Our office hasn't had any yet interpreting this new law. We have a couple eviction cases pending where we have one where a landlord gave a good old fashioned 15-day notice. And we're arguing it should have been 60, but no court rulings yet. Has anyone actually encountered this or any issues yet? It's still very
I've
very
got a
new.
Dade case where the tenant is thinking about doing the repair and deduct provision of the tenant bill of rights.
That's
That, I think, can
interesting.
get sticky.
That's going to be hard to prove, right? This is a Dade rule that they're talking about in Broward, nothing passed in Broward, where now if a tenant wants repairs, they have to give the landlord, a demand letter asking for the repairs. What Dade County has done is they've said, tenant, go ahead, you make the repairs yourself, and then just take it off the rent. which I think is going to get tricky because valuing it, how much did it really cost? I think is going to get really tricky. What do you think about that, Alex?
Well, the repair that the tenant wants is mold remediation, which is typically multi-thousands of dollars and a lot of construction. So I can see that is going to be a problem.
Whew,
The other
that
thing that
sounds,
they call about a lot is air conditioning, and that's also a multi-thousand-dollar item. So I could see one thing about fixing a toilet, but doing mold remediation or air conditioning replacement, we'll just have to see what the judges think.
yeah, I'm not sure how that's going to play out if they're basically not paying rent for a couple months, saying they put it in the repairs. Wow, that'll be interesting. So let me go back here. Now, brand new law just signed yesterday morning, as a matter of fact. But for anyone who does rentals, property management, I think there are some changes that you'll want to know about. It's called Mia's Law. Mia was, the story is she was a young woman living in an apartment in Orlando. And unfortunately, this maintenance worker at her apartment complex was like bothering her, harassing her, and she complained a few times and landlord didn't do much. And unfortunately, the story ends with one day the maintenance worker gets a key to her apartment and comes in and ends up killing her. And so the governor yesterday signed a law. And let's go through some of the new provisions. The first one is it requires background checks. For people who work, for the landlord, for the apartment complex. And it's a pretty thorough background check, focusing on looking for any violent criminal activity. But it's requiring these background checks for employees of an apartment complex. Let me throw a question to the group. Is this like an earth-shattering change, or do some properties already run background checks on their employees?
I'm not aware of anyone running background checks on their employees.
Yeah, that's what I'm.
I don't manage any apartment complexes at the moment, but our franchise does recommend background checks on employees. So that is something that is more common in our franchise.
That's good to know. I was with Alex. I haven't heard of too many doing it. And now it's pretty thorough. There's really not much exception that everyone's gotta pass a background check.
Yeah, I know a lot of my contacts back in Orlando, where I'm originally from. We both heard about this case when it happened, heard about the debate that's going through, and now that it's happening, they're realizing that a lot of people that weren't so involved with their buildings, a lot of the people they set up to do work in their buildings or sometimes even property managed were undocumented. So they're running into an issue where, because they're getting background checked, even though they may not have a criminal background, because they're undocumented, it's like a bunch of people are freaking out and leaving their jobs because they're worried about getting picked up by ICE.
Oh, I hadn't thought about that effect.
Yeah.
Yeah, I think.
How does it affect if you, like, for instance, like I said, I don't necessarily hire for apartment complexes, but I use third parties for my single family homes. How does the law affect that?
It's pretty broad, and we'll have to see how they interpret it. The statute talks about an employee of the actual apartment complex, but I think it'll be interesting to interpret how they, people you hire or a contractor you come in, if it'll apply to that too. That's a great question. Like I said, this is literally the ink is drying on this law, so I think we're gonna figure it out together. This one will be very interesting.
Jeff, I was
I don't
also,
know.
Jeff, I was also surprised that misdemeanors are included.
Yeah, if you see the background check, of course, it prevents anyone with a violent felony, but it also talks about someone with a first-degree misdemeanor, which are, pretty common, that it excludes those people as well. So that could be a very broad. I know some lawyers with first-degree misdemeanors in their
Whenever
background.
I'm doing a large remodeling job, I hire on other guys to come in, painters, stucco guys, whatever. At the very least, I Google them and then I go to the Broward County and the Dade County courthouse and I check to see if their name pops up for any background. It's not a great background check, but for my type of business, that's okay. I get a general idea of who they are. They're decent people. I can also check their reviews online to see if they're decent people.
Yeah, and I think that's what the legislature is saying, that this is the practice we should all be doing. Another change, I guess part of Mia's story is this maintenance worker was like coming in all the time, unannounced. So they did change. It used to be you had to give the tenant 12 hours notice that you were going to come in to make a repair or do an inspection or show the unit. And they bumped that up to 24 hours notice. So not a huge change, but they made it to a full day.
Jeff, on the notice, I find as a practical matter, the violations of that on either side, either the tenant not allowing someone in or the landlord not providing the notice, is sort of a misdemeanor in landlord tenant law in that it won't sustain a material breach of the lease.
I was gonna say, we get a lot of calls on this. My landlord only gave me 8 hours, gave me 6 hours, and there's not a huge remedy. It's like, are you gonna sue over that, or do you have damage? So there's not a huge remedy. It's kind of like an honor system. We just hope everyone follows it, and probably it's better for everyone when there's this clear communication of when to expect the landlord to come in. But very true, Alex. This next one, I think this is kind of a unique change, and this hasn't taken effect yet. This will take effect, I think, the beginning of the year. So one of the issues in Mia's case was that the maintenance worker kept getting, like, in a secret way, getting the key to her apartment and coming in and going. So they've created a rule that they want the landlord to create like a key log and establish procedures for maintaining a log of who's taken the key out, who's returned it, and kind of having an in and out documentation of any key to the unit. So this one, I'm guessing most properties don't have, just a guess. So it'll be interesting to see what people put in place to satisfy this. If it's just like a logbook, like when you check something out at the office, or how it'll go. So just something to be mindful of and thinking about as we go forward. I also wanted to talk about, like we said, a lot of changes in landlord tenant law over the last month. Last week, the Broward Commission passed some more law, and they're calling it a tenant's bill of rights. I'll tell you, it's not earth-shattering. When I went through it, it's not any monumental changes, but there are a couple little things.
Do you mind if I just really quick ask something related to Mia's law? I was curious about, it's, for example, if someone doesn't work with the complex, say it's key mismanagement, someone leaves a master key out and that leads to a break-in. How does that leave a landlord responsible? Because I know someone literally going through that exact suit in California right now.
Oh, that's a great question.
He actually didn't steal anything. He opened up the door to this apartment these two young girls lived in and sat on her bed with a crowbar until she woke up, but didn't attack anyone, didn't steal anything. But now they're in a weird suit situation because nothing was stolen, no one was attacked, but someone was able to break in with the master key the apartment complex left around.
That is a great question. And I wonder how they're going to enforce if they're going to enforce some of these laws, or if you're going to have to sue to enforce it. That's a great question. It really wasn't clear from the statute. So I think we're going to have to just wait and find out.
For that case to happen, yeah.
Yeah. A lot of these with this, most of landlord tenant law is like 30 years old.
They'll probably get rid of the master key and make sure there's only a single key for each unit that's in the office. You got to check out one by one individually.
That's not a bad idea. Yeah. But yeah, a lot of landlord tenant law is like 30 years old. We have long lines of decisions. It's very clear. This is all so brand new. We're kind of figuring it out as we go, which is a good segue to our next section. Last week, actually, just last week, Broward passed what's called their Tenants' Bill of Rights. And it's more, like I said, not earth-shattering or adding anything. It's more so just confirming what the law is. And like they created a new, really easy to use website, kind of, you can click on what each landlord tenant law is, and it gives a really nice, clear explanation. The one interesting thing I think they mention it here, they passed something saying that a landlord's got to notify the tenant if late fees are being imposed. Like if a tenant's late on the rent and the landlord's going to add late fees, they have to notify the tenant about that.
Is there a specific way in which that must be done? Because, for instance, we have a tenant ledger process in our system where, upon day 5, the late fee gets added to the ledger. Do we have to send reminders via email or something? What's the notification requirement for that?
Yeah, it just said written notice. So I think anything in writing is gonna work. It didn't really.
I think I could answer that.
Yeah.
In the past, before this ordinance was passed, many of the judges that I appeared in front of with regard to these landlord tenant cases in which landlord wanted to apply the late fee of say $100 or what have you, the judges have always asked, do you have any kind of proof that you have consistently been trying to collect that $100 late fee? You can't just all jumble it all at once. What you have to do is you have to show proof that every month you have given them warning or some kind of notice that you're applying this $100 late fee. And how you would do that is basically send them a simple invoice showing the rent amount that's due, along with a clear late fee on there. So then that way they know. And when you appear in front of the judge, they will be able to say, hey, you've been consistent on this, and not all of a sudden you added it all at once at the end of this because you're mad at the tenant and you decided to enforce it now. So that's how in the past the judges have interpreted it with me.
I think that's perfect advice. That said it 100%. Yep. And I've had the same experiences with in eviction court with Broward judges. So that's perfect.
Jeff, what is the website for that place? So I have somebody that needs to look at that. I didn't see a
Sure.
website.
Sorry, I will drop the link in the chat.
Thanks.
And yeah, the website pretty much has everything. So I'll definitely put the link in the chat here. While we're on this, one thing that they did put in the ordinance was that they wanted to remind everyone that rental assistance is still available in Broward County. The statewide program closed recently, but Broward County still has rental assistance for tenants behind on rent. Last month, they actually just got 22 million more in the rental assistance funding. And to tie into what we talked about, they are helping tenants facing rent increases. So if the landlord's given the tenant a notice that the rent is going up, I've seen the program pay for like 3 months of the difference, right, between the old rent and the new rent. So we've helped a lot of people with these applications, and they've been very, very successful. Just have to go on broward.org, and there's a big link button for rental assistance. So there is still money there, and it's been very helpful. One more change that that this new Bill of Rights talked about is they actually want landlords to give tenants a copy of this Bill of Rights. And a link to it will be in the link that I dropped in the chat to the website. There'll be a copy of this new Bill of Rights handout. Like I said, I don't think, and Basil, maybe get your interpretation, but I don't think it adds any brand new earth-shattering laws. It just kind of confirms and reminds people of what the law is.
As a realtor, my broker called me 2 weeks ago and said, Dave, you have to, that rental you're doing right now, make sure they get a copy of the Bill of Rights. So I had to actually copy paste that and email it over to my tenant and have them sign off on an email if they received it. So that's something you don't have to do as a realtor in South Florida or in any part of Florida.
Correct. Yeah, the ordinance says, landlords are required to distribute this notice. Oh, so how did you do it? You just sent like an email blast and attached it and everyone got it?
No, it was just one tenant. So I just went into the Broward County and I got the link and I sent her the link and said, please read this carefully and respond that you have read it and understand it and that you have received it. And she wrote back, received, read, and understood. Thank you. So I have proof that it was sent to her.
Perfect. Yeah.
And of course, I CC'd that to the other realtor and to the owner of the property.
That sounds like the way to do it. Perfect. Basil, what did you think?
Well, it's nothing like you said, earth shattering, because normally what you have to do is attach a copy of landlord tenant statutes to any lease that you provide. So because you have to do that, obviously, I mean, I don't think anyone's really going to thoroughly go through the statutes, but you have to attach them anyway. And obviously, part of good practice would be that you have them initial the bottom of each page, just like they would be signing the contract. So then that way, it could confirm that they are in receipt of it. So the same thing with regard to this, it's probably more of a summary of the statutes. So I would probably attach it standard and have them initial at the bottom of each page. So that way they know, and give them a copy. That way everybody knows that they reviewed it and they signed it.
That's great. Yeah, I think that's perfect advice. Again, you get double jeopardy. What is it in bonus? You've got.
What about existing leases? So do I have to do it for my existing leases?
That's how I read it. I read it that it applies to all landlords and all tenants, even existing ones.
I think it would be good practice to give this to your existing tenants, because let's just say it turns to a month-to-month lease in the future. They're going to say, you never gave this to me. I never knew anything about it. If you never renew the actual lease itself. So I would definitely make it a habit to give it to all my tenants now. So then that way, and confirm that they received it. So that way people like Jeff don't screw up your don't screw up your eviction matter by saying, oh, I never got this document.
I was just going to say, I think it's good practice too, because I do eviction defense. So just to give you my mindset, I'd argue that if I had nothing else to argue, I'd say landlord failed to give the notice, even if it wasn't really clear. That'd be an argument that I'd make. So yeah, I think that's great advice. All right, how's everyone doing? We've covered a lot of changes here. Before we get to questions, I just wanted to show you what other stuff our office does. We do a lot more than just housing. We have a whole family law unit that does injunctions, restraining orders, divorces. We've even started helping human trafficking victims. If you have any residents who are having issues with their public benefits, their food stamps, their social security, they got a letter that it's stopping, but they don't know why. We help with that. And We also have a special program for seniors that helps with a lot of legal issues, whether it be the ones I talked about, victims of fraud. We have a whole host of legal issues that we help with. So we actually we help low income residents of Broward, and all of our services are free. So we provide that. If you have any residents or tenants who are struggling or having a legal issue, definitely feel free to share our contact info, and we hope we can help them. We covered a lot. Any questions?
I've got one question for you.
Yeah.
California just passed a law requiring tenants to help, landlords have to now pay 1 month's rent for moving costs for any eviction. If they evict someone, they have to pay a month's rent towards the moving cost of the tenant. Do you think something like that might catch on nationwide? Because that sounds kind of crazy. I kicked the guy out, now I got to give him a month's rent to help him move. But that's the new law out there.
That's interesting. I don't see that happening in Florida. The changes that we've talked about, like, literally took years to get in Florida. I don't see that.
It's
happening.
kind of a crazy law. I mean,
That one's interesting.
I don't know how they passed that, but they did.
Yeah, please. Yeah.
I've got a question. Let's just say a person does have a lease, okay? And you don't want to renew that lease. Does this law apply to where you have to give that 60-day notice? I know the law says specifically month to month, but would that 60 days also have to apply to someone that does not want to renew the lease?
Good question. We talked about that in our unit meeting, and the way we read it, no. If you have a written lease and it has an expiration date, then that's the expiration date, and you don't have to tell the tenant that you're not renewing it. It just automatically expires. That's how we read it.
Well, the only reason why I'm asking is because I've had situations in the past before this was even enacted in which the judge basically implied there should be advance notice, way advance notice, even though everybody is in agreement that, this is the end of the lease, the state is the end of the lease. There should be some kind of advance notice basically saying that the lease is coming to an end. And basically, I understand that would be good practice, but in some scenarios, you have clients that don't exactly do the best practices. So you have to play with what cards you're dealt.
Definitely. I agree. Best practice. Did the judge cite a law on that, or is it just like a feeling?
The judge could not cite a law, and you could only do so much when it comes to arguing with the judge. So the judge did not assign a law, but definitely argued that was best practice. And I agree it is best practice, but best practice is still very vague in that is 15 days advance notice best practice, 30 days advance notice best practice, or is 60 days advance notice best practice? Since in a month-to-month situation, you have to give 60 days. Would it be the same, or at least advisable, that you have to do that in a actual lease with a date certain in which they have to vacate?
I agree. And I think it's best, I guess it's a good practice, and these tips are helpful. I'll just share my perspective from the eviction defense side. When we see an eviction filing or a notice, we're looking for defects. We're looking for ways to challenge it. So when you do all the best practices, and I'll just be honest, when we see one from Alex Johnson, I don't spend much time. I know it's solid. There's not any problems. It's probably the form that we use, and we need a form. So doing those best practice, incorporating those is really a helpful thing. Yes.
And one last thing, for one clarification purpose. Is it 60 days before, like the statute says, is it 60 days before the next rent due date, or is it just 60 days anytime?
I read it as before the next due date. So generally before the first of the month. Yeah, the same way 8357 talks about that. Yeah, good question.
So Jeff, I got an interesting tech-related question for you. A lot of people started to switch over to using tenant portals to manage these things, but because on the tech side, like these technologies are a little new or they have issues, if someone has, say, missed rent or a problem paying their rent that's a result of technological issues, say they paid it and it didn't go through, and then they start an eviction process, who is really responsible at that end? Is it the tech company for having a bad product? Is it the landlord for not checking in with the tenant they paid? Or is it the tenant for not making sure with the landlord? Because we've seen this exact thing happen with someone we know on the residential side.
That's a great question. I think, like Basil said, it might depend on the judge and the day.
Wow.
I certainly would argue if the tenant really tried to pay, I would certainly argue that they, made their best efforts and weren't at fault. And in a case like that, the tenant should still have the money, right? If it wasn't accepted or the portal didn't take it. So the tenant should still have the money and be able to pay the landlord or put the money in the court registry. And I think the situation would work itself out.
Yeah, like I pay my rent through an app in my apartment complex here, and people always ask me if we consider working on tenant portals, and I'm like, I'm just terrified of the legalities, that if there's a data breach or we screw something up, are we the ones responsible for that?
Yeah. And, we've seen cases with like a Dropbox, right? Where tenant puts it in a Dropbox and the Dropbox gets stolen. And I don't know if there's crystal clear law, but sometimes the judge rules, tenant gave it to the landlord, it was in the box. And sometimes the judges ruled, the landlord didn't receive it. So that was the tenant's risk of putting it in a Dropbox. So sorry, great questions. I wish I had a more definite answer.
No, it interfaces with a lot of different laws. That's why I ask, is like, no one really knows right now.
Good questions. David Pollack.
Yes, sir. So my question is for one of my clients. And this is literally, I just heard about this last week. The landlord called him after he paid his rent for this month and said the rent is going up 10%. Last month's is going up 10%. So he never got any kind of time frame, and he's scared not to pay it because he feels like he might get evicted. And he asked me what to do, and I said, I don't know. I heard about this law and I'm going to be on this meeting on Thursday. So hopefully I'll find out the answer for you.
That doesn't sound valid to me. Number one, landlord's got to give some type of written notice. A phone call isn't going to be enough to raise the rent. To do it after the fact, like backwards, I don't think that's valid either. I think you've got to do it going forward. And same thing, if it's in Broward, it's got to be 60 days. So it wouldn't
And if they do that, just say they do it, he's scared that the guy's going to boost his rent or throw him out. So would that be a client for you?
We'd probably take we definitely want to look at a case like that where there's some type of invalid rent increase going on.
Can you put the last screen up so we can get your email?
Oh yeah. Let me put
there you go.
And people can actually apply by calling us or going to our website, and they can apply for our services that way.
Thank you, buddy.
Awesome. Well, thank you. This was a great group. I really enjoyed it. It was an I feel like I learned some stuff. All of you, and I really appreciate you having me and getting the chance to talk about landlord tenant law.
Well, Jeff, the most important question is, are you coming to Denny's next week?
I am all in for I love Denny's. Grand slam. Awesome.
Jeff, one more question.
Of course.
Is this it for Broward? This is all they're going to do with the tenant bill of rights? Because that's nothing like what they did in Dade. I was just thinking about that because Dade had a lot more. I
I think it's an ongoing conversation in Broward, right? They did something in May, they've done something in June, and kind of the same groups that were working in Miami are working on Broward. The same like organizing groups and tenants' rights groups. So I think there might be some more updates to come.
Because what I thought was interesting about the Dade Bill of Rights is it gives third parties a cause of action if they're involved in the landlord's misbehavior. And
Right.
also with a potential award of attorney's fees.
And that's significant, right? In enforcing these rights, that can be very significant.
Right. Also, I thought was strange about the Dade bill is to threaten eviction could be actionable. Not just a wrongful eviction, but the threat of an eviction is a violation.
That was interesting too. And again, I wonder how some of these are going to hold up to any tests. But yeah, that was very interesting. Very interesting. Yeah, it's just a unique time for a law that doesn't change for 20, 30 years and then has a bunch of changes in a short period of time. I mean, I think part of it was the pandemic and all the rent increases down here and people being priced out. I think this was some kind of reaction to that. So it'll be very interesting to see how these laws play out and what happens next.
Well, thank you very much. And also thank you for such a detailed PowerPoint presentation, even with the sound effects. So much appreciated.
Thank you.
Hope we'll see you again.
Definitely. Thank you for having me.